Welcome to Education in Focus. I'm your host, Aliana Kernodle. Requests by the federal government to stay injunctions over the Biden administration's controversial Title IX rule have been blocked by the U.S. Supreme Court. Joining me to discuss this is Chalkboard News editor Brendan Clary. Brendan, what was the federal government asking for in this case?
Yeah, that's a great question. So basically, in two cases that were in the Court of Appeals for the Fifth and Sixth Circuits, the Department of Justice, the federal government's attorneys, basically, they asked the Supreme Court to allow the government to implement Title IX, all the other parts of it that were not currently being litigated. So basically, the ask was, let us implement the parts of the Biden administration's Title IX rule, the expanded rule, that aren't being challenged by these states and where these injunctions are in place. So basically, the government said, you can't put any of this into practice because we're talking about it. Like, courts are able to say, hey, this is controversial. This is like a rulemaking thing from the government. You can't do this while we're talking about it in court because it could have potential harms for those that you're implementing this against. Like, there could be constitutional harms, and that those who are arguing that it could be harmful have merit. Like, there's merit to their argument. So we have to be able to, we are going to do this so that we don't have that, right? And so these are all based on legal doctrines and precedent and all that kind of thing. And again, it gets really complicated really quick. But essentially what the Department of Justice then was asking is, we're asking for them to give us the ability to implement the rule that is not related to these, like, basically three parts of that relate to gender identity and that are controversial, right? So that are like about, locker rooms, things that you hear a lot about in boardrooms and a lot of these kinds of like hot button issues that are culturally there. Because a lot of it, they're arguing is like, this is fine, we can implement this. And I'm happy to talk about those too. But that's the basic overview of this is the government was like, we should be able to implement this. Don't you agree? And then the Supreme Court said in a 5-4 ruling, no, we don't agree. Like, you are not allowed to implement the policy, like the Title IX rule, in these states where there is an injunction.
So can you get into that of what is in the rule that's not controversial? Because I feel like a lot of people have heard about, and we've talked a lot about the controversial parts, which is the stuff concerning locker rooms, transgender athletes, things like that. But what else is in this rule that the Justice Department wanted to implement in the meantime? Yeah,
that's a great question. So one thing that that Justice Sotomayor wrote about in her dissent was some of those issues. And she basically laid out, you have protections for students who are pregnant or who maybe have to breastfeed, and that there are protections in there against asking an employee about their marital status. So these are things that are not really controversial. These are kind of updates to the law. And I think that you could even say that they're in line with different other kinds of discrimination law or non-discrimination practice, like widespread. And I mean, we've seen a couple, there's been laws in a number of different states that have governed like different protections for pregnant women and those kinds of things. And so these are not like bad things, and like they're really not controversial. Like, they're not being brought up by plaintiff states saying like, hey, we don't want these parts of it. There's these different kinds of things that are not. I'm trying to think. There's another one that prohibits staff and students from retaliating against students who file Title IX complaints, and provides a specific procedure and requires staff to know the law. And so those kinds of things are not being challenged. And like, I think that's something that the dissenting opinion says, we don't really, like, nobody has an issue with these. Like, there's not really any problem with having, retaliation protection. Like, you like, nobody wants somebody to get in trouble for saying like, hey, there's a potential issue at my school. Like, I think that's pretty non-controversial and not something that you really see in the news, that there's a lot more to this rulemaking than just the controversial stuff. But that's really gripped a lot of attention, right? A lot of headlines, a lot of stuff that we write about is about that, but there's a lot more to it. I mean, that's part of the expansion of the sex discrimination, is to include all of these other things as well. And so I think in some contexts, people might say, oh, that's too far and it's harmful. And then in these other contexts, they might not really have anything to say because they don't really have a beef with it. And so I think that is sort of the argument of the dissenting and also the government. So like the Department of Justice was arguing just that. Like, a lot of this rule is fine and we should implement it while we figure out the other stuff.
So then what was the reasoning that the Supreme Court gave for rejecting the request of the Justice Department?
Well, that's a great question. What they basically said is that it's too intertwined. And they basically said, there's a lot of, everybody wants to talk about these things that are challenged and like there are these specific things. But the argument that the majority opinion had, the 5 justices who agreed with this, they basically said that things are too, they're not readily severable from the remaining provisions, that you can't really take these things and chop it up into little pieces and say, like, let's implement this and not implement this because they're sort of built into each other. So they say that the lower courts concluded the new definition of sex discrimination is intertwined with and affects many other provisions of the new rule. So basically how they built it, how they intended it is that if you expand gender identity or you expand sex discrimination to include all these other things, then you're building the rule around that. And so I think that you kind of get into like, maybe some of like the form of the rule versus the structure of the government, and sort of like these other bigger questions about like, when you have a rule, do you like follow the intent of like, this is how they built it? Or do you go into like the practice of like, shouldn't we be protecting these people? So it might be some of that going on there too, of like looking at different scopes of it. But essentially at this stage, they said that the allegedly unlawful provisions are not readily severable from the remaining provisions. So they're going to go along with that.
Yeah, and I suppose that a big part of laws is how they're written and what language they use. And even if perhaps what it's doing isn't controversial, it still matters what language was used to make that rule and that kind of thing.
Absolutely. And I think that that's especially important when you're starting to split words and get into the constitutionality of it. When you're at the Supreme Court, they're going to investigate everything, and you have like a lot of jurisprudence going into that. So absolutely that matters.
Well, Brendan, thank you for your insights on this story. I'm sure this will not be the last time we talk about this. It's kind of been an ongoing story throughout the summer, and it's nowhere near over. So listeners can keep up with this story at chalkboardnews.com.